one of the hot topics that is going on in Karnataka today, that is hijab controversy. So we will look at the different aspects of hijab controversy and what the constitution has to say and what the Supreme Court judgment has to say, as well as what the Kerala High Court judgments have to say. So basically, we'll cover the constitutional aspect rather than the political aspect of hijab controversy that is going on in Karnataka. So as you all know, why this issue is there in news, first of all, because some six students in Udupi district, they were not allowed to enter into the college because of the hijab that they wore. And also, this has not just limited itself to the Udupi district, now it has spread throughout Karnataka. Now there is a debate going on whether Muslim girls can wear hijab to the schools. And also, by countering this, some Hindu boys, what they have done is they have wore this, they started wearing these saffron shawls to the school, to the college. And they are like, if you are allowing Muslim women to wear hijab, then we would wear saffron shawls because that is something which we practice in Hinduism. So there is a kind of controversy that is going on and a fight between two um, religion which is witnessed here. Now, if you want to look at the issue a little deeper, there is a classic conflict. Now, what is the fundamental right that is being discussed here? So, again, this is the fundamental right to freedom of religion. Now, if you remember, if you recall from what we learned in last class, so we saw anti-conversion bill. So, in the case of anti-conversion bill, as well as in the case of hijab controversy, in all these cases, fundamental right to freedom is under question. So this is covered under article number 25. We saw how there was a controversy that was going on with respect to article 25 with respect to anti-conversion bill. And also you should remember that it is a very important aspect when it comes to the preliminary examination this year preliminary examination, because lot of issues are going on with respect to article 25, and also UP elections which is going on, that has also resulted in a lot of debates over article 25. So what is the challenge here? What is the challenge if you ask that question? So here the challenge is between the freedom of religion, that is the right to wear a hijab, whether it is constitutionally protected, or does the institution, educational institution, have the right to prohibit these girls from wearing hijab? Who has more rights? A kind of conflict of rights, or you can say fight between rights. So does the institution, educational institution, have the right, or does the Muslim girls have the right to wear the hijab? And since the issue has spread out to many other parts of the state, the government yesterday evening, I got to know the news. Yesterday evening, the government has issued an order to ban girls from wearing hijab, or not just girls. It has banned all kind of what do you say, religious attire that was going to be taken to the schools, that has been prohibited by the Karnataka government. Now, first of all, we will see how what the constitution has to say. Does the constitution agree with Muslim women wearing hijab or not? The constitution does not say much about that, because the article of the constitution which deals with this issue, that is article 25 clause 1, it guarantees, we have already seen this last class, so once again we will see freedom of conscience, right to profess, practice, and propagate religion. Now, in the case of anti-conversion bill, the fight was between the freedom of conscience and the freedom to propagate. But here, the fight is for the freedom to practice religion. So, practice religion, Anta, if you ask that question, then Muslim girls are going to argue that wearing hijab is the way in which they are going to practice their religion. And that right is guaranteed by the Constitution. The Constitution very clearly says to practice. So, wearing hijab, that is a ritual, right? That is a way in which they are going to practice their religion. But again, as with respect to all fundamental rights are not absolute. They are given to the citizens and they can be enjoyed only subject to the restrictions imposed by the state. Just like all fundamental rights, Article 25 is also subject to the restrictions. Who can impose these restrictions? It is the state which can impose these restrictions. So basically, Article 25, it also has restrictions under public order, decency, morality, health, and other state interests. I can just give you an example. Let's say there is some religion in India which is practicing human sacrifice. Human sacrifice ಅಂದ್ರೆ ಗೊತ್ತಾ? Like killing human beings, sacrifice ಮಾಡೋದು human beings ನ. And it is going to say that what do you say? That religion is going to say, I am like I have the freedom to practice. I want to kill. I want to sacrifice human beings. ಅಂತಂದ್ರೆ no, that is not allowed. If that is going to affect the public order that is there, then such activities can be restricted by the state. And if decency is in question, if morality is in question, if health is affected, in all such cases, the state has the authority to uh, prevent the individual from exercising his fundamental right. What are, first of all, reasonable restrictions? And second of all, who decides these reasonable restrictions? And obviously, this question, hmm, yes, it is a national issue ಅಂತ ಹೇಳ್ತಾರೆ. That's absolutely right. Now, even it is being discussed in JNU and also in, especially, see, the political aspect is currently elections are going on in major states in India, and that is why there is this issue. After some time, it will automatically go away, but UPSC will ask a question on this because there is a debate going on whether the women, that is Muslim girls, have fundamental rights or not. So this question was asked in Supreme Court: what are reasonable restrictions and who decides them? And Supreme Court, in the year 1954, in Shirur Mutt case, please underline this, Shirur Mutt case, Shirur Mutt case ಅಲ್ಲಿ it has what do you say, prescribed something. What it has prescribed ಅಂತಂದ್ರೆ, it has given the test to determine what rights are constitutionally protected and what are not. What religious practices are protected by the constitution and what are ignored. So here, what are the, for example, I'll just take this example of Muslims. What are the practices of Muslims that are protected under the constitution and what are the practices that are not protected? Hindus anta bandre, just like that, Hindus also. What are the practices that are protected by the constitution and what are not? This is called as essential practices doctrine anta karitare. Supreme Court has termed this as essential practices doctrine. So what is this essential practices doctrine? Here, which are like I mentioned this question, which are the practices that are allowed by the constitution? The practices that are allowed are those practices which are essential for a person to perform his religious duties. Very simple answer. Which are essential practices? The practices that are essential for the performance of his religious duties. For example, you cannot ask a Sikh, Sikhism is one of the religion. So you can't ask a Sikh to not wear turban because wearing turban is the way in which Sikh will fulfill his religious duties. ಅದೇ ಅಲ್ವಾ ಅವ್ರದ್ದು ಮೈನ್ ಐಡೆಂಟಿಟಿ, ವೇರಿಂಗ್ ಟರ್ಬನ್. ಇಫ್ ಯು ಸೇ ವೇರಿಂಗ್ ಟರ್ಬನ್ ಇಸ್ ರಾಂಗ್ ಅಂತ, then the Sikh person will not be able to practice his religion, then that will be a violation. So wearing turban for Sikhs is essential practice. Now, This is the question which we shall ask in this case, hijab case which is going on. Who decides if the practices are uh, essential and healthier? Okay, I'll answer that question. I'll answer a little later. Now we'll ask the same question when it comes to uh, hijab controversy. Here, is wearing hijab an essential part of Islam religion? So women, are they going to say that wearing hijab, only by wearing hijab they will be called Muslims? Is that the question that is to be asked? Shirur
And
Mat case, in this case itself, Supreme Court has told that what constitutes essential part of religion is to be ascertained by the references to the doctrines of that religion itself. So, if you want to find out if that is a part of religious, essential part of religion or not, then you should look at the doctrine of the religion. Doctrine of the religion means you should look at the what do you say? You should ask someone who knows about the religion, or refer to some text that is there, Quran nodi, ಅಥವಾ do something like where you can ascertain whether that is an essential part or not. That is what the court has told in Shirur Mat case. And ultimately, who is the authority in ಹೇಳಿದೆ? Religious practices are to be determined by the courts. We
I
have
think
so far seen three cases in which this question is answered by the court. First case, we will see, it was a case in 2016, a Muslim Air Force soldier who was there. This Muslim Air Force soldier, I don't know his name, but he wanted to keep his beard because keeping beard, he says, is a part of Islam religion. But there is something called as Regulation 425. Let's not worry about what that is. But this Regulation 425, in the Armed Force Regulations of 1964, it particularly prohibits the armed personnel from keeping their beard. So they are supposed to, what do you say, cut their hair. In army they will very clearly they'll specify that you have to cut your hair to such an extent and ಹೇಳ್ತಾರೆ. But one exception is provided under this regulation, that is, except for those people whose religion itself prohibits cutting of hair or shaving of face. The Sikh religion itself prohibits Sikhs from cutting the hair or shaving their face. Now you might ask me, sir, I have seen so many Sikhs who cut their hair and like who shave their face and that. That is that person's right. He is following that. Probably we are not worried about that person's right. We are talking about the religion. The religion is specifying. Now the question is, does Islam also prohibit men from cutting their beard or cutting their hair or shaving their beard? That was the question which was asked. And what the court did was it went to a person called as Salman Khurshid. Salman Khurshid is a kind of friend for Supreme Court. He is a senior advocate. So the Supreme Court asked him the question: is it essential practice? Now let us again get back to this term, essential practice. What do you mean by essential practice? Those practices which will help you to fulfill your religious duties, they are called as essential practices. Is keeping beard one such essential practice? That question was asked to Salman Khurshid, and Salman Khurshid said no. Keeping beard is desirable. What do you mean by desirable? It's good if you keep beard. As per Quran, it would be good for you to keep the beard. But like being a Muslim, that is a choice left to you. If you want to be deeply religious, then probably you can keep the beard. But that is not an essential practice, and that is why the court in the year 2016, it was three-judge bench of Supreme Court. It held that keeping beard is not an essential practice in Islam. So that person, that is the Air Force soldier who was there, should have actually shaved his beard. But if it was a Sikh soldier who kept his beard, then he is allowed to keep it because that forms an essential practice of Sikh religion. This is the test that the Supreme Court has laid. Next, we will see one more case, that is Kerala High Court judgment of 2015, in which CBSE CBSE, while conducting pre-medical entrance exam, It had prescribed uh, students to wear light clothes, half sleeves, not having buttons, not having flower badge or something like that. This was again questioned in the court. Same controversy. ಏನಪ್ಪಾ ಅಂದ್ರೆ, are Muslim women allowed to wear hijab to the examination? And what do you say? The Kerala High Court here favored CBSE. Favored CBSE. Why did Kerala High Court favor CBSE? ಅಂತಂದ್ರೆ Kerala High Court specifically told this, the dress code which is prescribed by CBSE, it is not to what do you say, prevent people from exercising their religious practices. It is to prevent the unfair methods that might be used in the examination. For example, you can hide some chit in your hijab and probably enter the examination hall, and you can't say that it is my religious right to wear hijab and also I'm going to keep chit inside this. That is not the right which is protected here. So here, Kerala High Court very clearly told the rules put by CBSE, restrictions put by CBSE is correct. It upheld the rules, but it put one condition. That is, yeah, if you want, you can wear hijab also, but those people who are wearing hijab should be subjected to additional checking. Andre, there should be enough what do you say, security measures to ensure that you are not carrying any what do you say, chit or anything along with you, and you are not performing any malpractice in the examination. So that has to be ascertained as per the Kerala High Court judgment of 2015. Next, there is also another related judgment. Again, this is also in Kerala High Court. That is Amna bint Bashir versus CBSE. That was also in the year 2016. So here, Justice PB Suresh Kumar, he has examined these practices in detail. So he held. See, this is a very important point. Please underline this point. Kerala High Court in Amna bint Bashir versus CBSE has held that wearing hijab is an essential practice. That is, I mean, keeping beard is not an essential practice as per Supreme Court. Muslim men, they can keep the beard or they can shave the beard, that is left to them, but that is not an essential practice. But for women, wearing hijab is an essential practice, is an essential religious practice. As per which judgment? Amna bint Bashir versus CBSE 2006 judgment. 2016 judgment, I'm sorry. So, you might be wondering, sir, if that is a part of religious, essential religious practice, then should the Muslim woman be allowed to wear it? The condition has been put. That is, yeah, you can wear it. You can, if you want to, if you are visiting some shopping mall, if you are visiting a movie, if you are going to some marriage, you can wear it. But if you are going to the examination hall, then you can't claim that it is your religious right to wear that. This is a very keen observation that was made in Amna bint Bashir. So it upheld CBSE rule. It did not quash the CBSE rule. And even it put more additional safeguards also compared to previous year. So it said in both the cases where the freedom of religion restriction is placed on the freedom of religion, but that is for a specific purpose. What is the purpose? To prevent malpractice in the examination. For such a purpose, public order. Remember, now let's go back to the what the constitution has to say. So the state can restrict the rights for the ground of public order. Do you see this? To maintain public order, the state has imposed such a restriction, and that restriction is valid as per Amna bint Bashir. But we will ask this question, that is, okay, Muslim women have the right, that is, wearing hijab is an essential practice as per Islam religion. But can they wear it to the schools? Wearing it to the examination is prohibited. But can they wear it to the schools, regular classrooms which are there? Ali, there is no examination, they are not going to hide anything inside that hijab. So can they wear their hijab to the schools? Is the question which is being asked now in the current scenario. This is the question which is there. And we have an answer for that also. That is Fatima Tasneem versus State of Kerala in the year 2018. Again, this was also questioned in High Court. So, what was the question, Andre? The case involved two girls. I mean, the girls were age 12 and age 8. These are the two girls who were represented by their father. Uh, their father wanted these girls to wear headscarf and also full sleeved shirt. There is a kind of, what do you say, in Quran it says that a Muslim woman should display her beauty only in front of her husband. So they are supposed to wear full sleeves. They are not even supposed to show their faces. They should cover their faces. It is as per Quran. But however, what the Kerala High Court did in this case is a very interesting thing. Here the fight was between the uniform, that is the school uniform which was given, versus the right to religion, freedom of religion, right to religious practice and something. Now, when you are studying in a school, you are a part of that school. You do not belong to any particular religion. You are not a Hindu, you are not a Christian, you are not a Muslim. So, if you take religion to the school, what will happen? Then you will be branded as a person who belongs to this particular religion. That possibility is there. And by the way, this question was regarding some Christian school. Christian school actually prohibited um, people from Islam to wear this headscarf, and full sleeved shirt. And in this case, Fatima Tasneem versus State of Kerala, very clearly the Supreme Court has ruled that the right of the institution, that is the larger right of the institution. Which institution? It is the school in this case. The school also has the right to make its own rules. School has its own, for example, even these in some Christian schools, Hindu girls are not allowed to wear bangles, or they are not allowed to keep bindis. So that is there. So that is the right of the institution, that is the larger right of the institution versus an individual right of one person. See, wearing hijab is the right of one person, that is that particular person. But institution has the right to, what do you say, maintain uniformity, ensure equality. That is what the court has held in Fatima Tasneem versus State of Kerala. Now, ultimately, what is going to happen? Again, currently, this is there in Karnataka High Court. The petition is there in Karnataka High Court, and we'll have to see what the Karnataka High Court is going to take the call. Then there is criticism for this essential practices doctrine. Why is this being criticized, Andre? Why is first of all court interfering into the matter of religion? Court, it has its own job to protect the constitution. All court should do is prohibit the practices which are against public order. Prohibit those religious practices. What you are going ಏನ್ ಮಾಡ್ತಿದ್ದೀರಾ ನೀವೇನ್ ಮಾಡ್ತಿದ್ದೀರಾ? You are getting into the religion and you are going to say, you are going to decide which one is right and which one is wrong. Why is it right? You are getting into theological aspects, theological spaces that should better be left to the religious gurus to do. As a court, you should only prohibit the practices which are against public order. That is what the current criticism that is there about the what do you say, essential practices doctrine of Supreme Court in Shirur Mat case.